also note that when there's case law out there that discrepancies in instructions becomes problematic. It might be difficult to know which instruction jurors relied on in making a decision. And this, of course, is perhaps the most important instruction as it defines the state's burden. So really, for just the practical purpose of keeping this jury not confused and not submitting to them a new and different instruction than they've already heard on multiple occasions, because this trial's already been going before this new instruction was implemented, I am going to give what I'll refer to as the old jury instruction 103. And I should say, give it again to the jurors. They've already heard it multiple times. And the one that we've included in our proposed instructions mirrors that they've already been read. I am going to provide that, finding that under the Victor versus Nebraska standard, it still adequately conveys to the jury that it must consider only the evidence and properly states the government's burden of proof. And also, while the new instruction may be better, finding that the Sheehan language that this instruction we've got has an accepted history of defining the burden in the state doesn't mean it's now an improper instruction. Maybe it's just not as good as the new instruction, but it, I think, has a real risk of potentially confusing jurors and confusing the record potentially on appeal about which standard they then employed, getting two separate instructions during trial. So with all that said, the court is going to provide instruction number 5 and overrule the objection of the defense on that particular instruction. All right, the next instruction we're going to take up then is number 14. And Ms. Beatty, you had some comments on 14.
Yes, Your Honor. In number 3, actually, I take that back. So underneath, certain things you have heard or seen are not evidence, including, I'm just looking at number 2, testimony that has been excluded or stricken, or which you have been instructed not to disregard, or which you have been instructed to disregard. We are just looking to add the words and or questions. So testimony and or questions that have been excluded or stricken.
All right, response, Mr. Pryor.
I don't think there's a need to put in the words question, Judge. It's testimony. It's in general. Testimony is broad enough that I think it's unnecessary.
All right, I've considered that request from the state to modify instruction number 14, subpart 3 of the instruction, subsection 2 currently reads, certain things you have heard or seen are not evidence, including testimony that has been excluded or stricken. State requests that questions be added to that language, given the nature of, well, not the nature, but just the extent and number of times the court sustained certain objections throughout the trial in the form of questions and was requested to strike the question, not necessarily the testimony. The court does find that this would be a proper instruction to clarify to the jurors that they do not consider what may have been perceived to be testimony because it was coming out and while a witness was on the stand, but was in fact a sustained objection on the record to a question itself. And the court did expressly strike or grant motions to strike questions that came up in witness testimony. So I am going to add that modification and it will read under part 2 testimony or questions that have been excluded or stricken. And we'll put that as part of 14. Council, I think that covers then the jury instructions we had. So to recap, I've made those rulings. With those rulings now made, does the state have any further objections or does the state approve the instructions with the court's new ruling?
Your Honor, the state approves them.
All right. And Mr. Pryor, I know I overruled a couple of your objections, so I'll ask that a different way, but the list I wrote or went through in the beginning, is that still accurate in your mind?
Yes, Judge.
Okay. And despite a couple of rulings against your requests there, is there anything else you think needs to be addressed in the jury instructions?
No, Your Honor.
Okay, well, thanks all for helping us get these prepared. Scheduling then, we're going to get these done and distributed to the parties by tomorrow morning. You'll have them. We'll have the copies prepared for the jurors. We're going to start with the court reading the instructions at 10 o'clock a.m. and then closings will take place. Does that schedule work for the state?
It does, Your Honor.
Does that work for the defense?
And Judge, I missed the part. We're going to have copies when?
Well, we'll get the final copies of the instructions. I don't know that we'll get those to you this afternoon. We'll have those to you ready though in the morning, well before 10 o'clock.
Okay.
I would say they would be ready tomorrow morning, probably by 8:30.
Okay, that would be perfect. Thank you, Judge.
Okay, we'll get those. Thanks, counsel, for all the hard work today. Anything
you,
else
Honor.
before we go off the record?
No, thank you, Your Honor.
Nothing, Your Honor. Thank you.
Not on the record, Your Honor, but the state was wondering if we could meet with the court and council just very briefly on some scheduling issues.
All right, we'll take up a sidebar then before the court recesses. So we're done with the hearing then, off the record, and I'll talk to counsel then off the record. Thank you.